This episode, we shall discuss one aspect of the forthcoming Digital Personal Data Protection Bill 2022, which is called DPDPB 2022, which is expected to be presented in the Parliament in the second half of the current budget session. See, one of the discussions which are ongoing, which I am also trying to promote, is that in India, we need a separate legislation for artificial intelligence regulation. The idea is that artificial intelligence is a system which, if not regulated properly, it can go out of control of humans, because we are today talking of artificial intelligence and machine learning, which is programmed to self-learning mode, in the sense that once the AI algorithm is released to the wild, the human control over that ceases, and it starts improving the algorithm itself by the experience which it picks up in the use of the algorithm. Like, for example, the natural language processing, NLP, which is being used. Now, as and when public start using a algorithm like this ChatGPT also starts learning. And when it starts applying its own learning in its future outputs, it becomes more intelligent than the human beings at a particular level. Now, the basic AI concept is that certain instructions are given to the software and it executes those instructions. Those are the simplest form of AI, which you can call as ANI, which are the type of, say, chatbots we see in some websites, which are good to nothing kind of, say, relationship management with visitors. But as and when the new generation of chatbots come up and they are intelligent, and maybe in the physical world, we will also see robots, humanoid robots in restaurants or shops, we will be reaching a situation where the AI algorithms start improving based on its experience outside. Some of these new generation AI is programmed to understand the emotions of the people based on face reading, whether the person has got red eyes, whether got facial expression which shows anger, sadness. This the AI can sense and correspondingly modify its activity. So it is becoming more and more, say, intelligent and trying to become more like a human being, which in due course could lead to a situation where it will totally override the earlier instructions and start acting on its own. That is the risk which we are having in unregulated self-learning capabilities of AI algorithms. Therefore, we are debating that we should have a separate law, we should have ethics, and the developers should be made accountable, and certain restrictions are to be placed on the AI with a kind of a kill switch so that you can disable the AI if it is becoming a rogue. Now, while a new AI Act will take its own time, and knowing how the lawmaking in India moves, it may take several more years before even the government starts drafting a law. What I personally feel is that we have to make the best use of the existing laws for the purpose of regulating AI. So one such opportunity is available in India because one, the Information Technology Act 2000, which is effective since 17th October 2000, itself has one provision under attribution of the actions of an automated device, where the actions are attributed to the owner of the device. Actually, Section 11 of ITA 2000 says an electronic record shall be attributed to the originator if it was sent by an information system programmed by or on behalf of the originator to operate automatically, which means that the person who takes the, let's say, responsibility for the AI is the originator, who is a human being, and he will be responsible for all the activities of the AI. In that sense, if an AI goes rogue, it is the developer or the person who has purchased the rights from the developer who will be held responsible legally. This is there in Section 11 of Information Technology Act. Now, the new DPDPB 2022 has one provision which defines what it means by automated means of processing of data. And it says automated means any digital process capable of operating automatically in response to instructions given or otherwise for the purpose of processing data. The first part of it, that is instructions given, is directly corresponding to the software where there is a developer, he sets certain instructions, it is there in the library or whatever is the database, and the software makes a reference to this database and gives output based on whatever input it receives. And it also contains the word or otherwise. So under this or otherwise, we can consider that if there is a software which takes instructions today, and the instructions include that you can modify my instructions based on what you learn from the outside world, then this modification of the instruction also becomes part of the original instructions. And over a period of time, even if the original instructions are completely overridden and a new set of instructions are generated because this is a self-learning AI, that will still be covered under the definition of automated, and you can invoke this word or otherwise to represent such situations where the software is working beyond the instructions given at a particular point of time. So if an AI goes rogue, that is the time when you have to say it is acting otherwise than on instructions given, and therefore that becomes an automated processing as per the act. So whatever restrictions or compliance requirements are there in the act, in terms of the principles, in terms of the rights, in terms of the penalties, they all apply to a situation where there is an AI algorithm which is working for processing of data. Therefore, we can say that AI is already under the data protection bill as envisaged. There is also in the background the concept of due diligence, which Information Technology Act has ingrained in the activities of an intermediary. See, data processor who uses a AI obviously is an intermediary. In fact, AI itself, even if it becomes independent, it becomes an intermediary, and we are attributing the responsibility of that intermediary to the person who caused it to act automatically. So there is accountability which is there in the particular regulation itself. Now, the intermediary responsibilities state that there has to be due diligence and reasonable security practices. What they mean is that the software or the device shall be managed in such a manner that it actually does not violate any provisions of the law, which means that the organization which takes ownership for the AI is responsible for implementing the best practices regarding security and other way of handling the software. And when we say best practices are those which are ingrained in the law, in which case it becomes a legal obligation. Then it is ingrained in the industry practices, in which case it becomes a standards of the industry. And what about this? What is good for the society is also a due diligence, because no citizen, whether individual or a corporate, is expected to act in deference to the well-being of the society. In fact, this is a duty under the Constitution. Therefore, we can say that from the concepts of Section 11, which is a contractual obligation, to the definition of automated means and the due diligence concept, which extends the DPDPB 2022 bill provisions as well as the internationally accepted standards and good practices into the Indian context of data protection, which may also include the AI ethics. Okay, so AI ethics, which are already under discussion under the various forums, and the UNESCO itself has given a sort of a recommendation, that becomes due diligence as far as the implementation of the obligations of an Indian company is concerned. Therefore, we can derive a thought that India at present will be able to say that we have a regulation for artificial intelligence, which is through the Information Technology Act and the DPDPB and the concept of due diligence. So therefore, any organization which is manufacturing and supplying the AI algorithms must have a DPO, must conduct a DPIA. They must consider themselves as significant data fiduciaries, because the risks are not very apparent. So the risks are hidden to some extent. So the sensitivity of the information handled and the risks are little too much for it to be considered as an ordinary data fiduciary. So it will be a significant data fiduciary. They have to conduct a DPIA. And in fact, the DPIA report must be part of the manual which the organization will hand over when they sell their license for the AI. So I think this is the message I want to convey. Let us not wait for a new law on artificial intelligence. Let us not even wait for the DPB 2022 to be passed. We shall presume as of today that we have an AI regulation in India driven by ITA 2000 and supported by due diligence in various forms. So friends, this is what corporates should start working on right now. Thank you. If you have any questions, please do write to me. You can visit navi.org where my contact details are available. Otherwise, you can send an email to me. Even my telephone contact would be available under navi.org. Please do write to me your views. And if possible, if you want to continue to listen to me on such issues in future, please subscribe to this channel. Thank you.